So I just wanted to get this information out there quickly on the Siegel v. Platkin matter, the case that was combined with the Kuntz matter. There was an order entered today. This is, let me guess, I think we are now at the stage for a temporary restraining order, which is going to last a little bit longer than the initial order until there's further briefing and hearings on this case. A lot of people are asking, why did the judge not rule on all the different elements of the case? And why did the judge not rule with respect of all the different sensitive places? Well, don't take advice from any lawyer on the internet, and don't go running around there saying, I can carry here and I can carry there, Mr. Prosecutor, because any lawyer on the internet says so. That being said, many of the lawyers that are connected with these advocacy groups and Four Boxes Diner and the other ones, Armed Scholar and the rest of them, are doing an excellent job with their analysis. But I just want to answer the question as to those sensitive places that are not included in the order. In some cases, the plaintiffs didn't raise them for strategic purposes. They're closer calls, they're harder questions, they're places adjoining to schools, things that the Supreme Court has said, wouldn't necessarily be overturned by Heller or Bruin. And the other reason is the judge on some of them, in my opinion, the judge said, well, these are tougher questions for me. I don't know if I can handle these on a TRO. So the judge looked at the affidavits and said, well, this person said they only go there sometimes. They go hunting, but that will be in the fall. So we're 11 months away from next fall. So they're just not ripe for decision at this time. So in my reading of the entire decision, I don't see a single place where the judge says, oh, that will clearly be upheld because that is a school. There was an issue with playgrounds, and the state said, well, most playgrounds are at schools. And the judge says, well, that's true. Many playgrounds are at schools. But by that same token, the state then argued, so it should also extend to any place where, and I find the irony of this, unprotected or undefended children can go. Okay, so if I'm taking my kid to a park where a bunch of kids are going to play and these kids themselves can't provide for their own safety, you're now disbarring me of the right to provide safety for those kids. What an asinine argument by the state. But anyway, the judge did a great job. Judge was clearly frustrated that the state raised arguments that she already shot down in Kuntz. And with respect to these places where the judge says, okay, we're not going to deal with those in terms of the TRO, I think she did a good job of looking at the affidavits and saying, well, if they said we're there frequently or several times a month or regularly, then we're going to deal with that issue in the TRO. If it's a place that they go to on occasion or plan to go in the future, like zoos and other places, we have time to deal with that. We don't have to deal with that in the TRO. So that was kind of a legal maneuvering there. It doesn't mean anything with respect to where the judge will rule on those issues. It just means the judge wants to, determine the case more globally, figure out how she's going to apply those Supreme Court decisions, and then is going to require some further investigation and argument and briefing over the issues of these places that may actually be connected to schools or whether there is a historical analog to them. Not just courthouses and schools and, places like that, are there, analogous historical, prohibitions that were in effect that might actually satisfy Bruin. So basically that's where we are. Don't know when there's going to be further hearings on this, but, we do have a more defined list of the places where you're allowed to go. It's very confusing. Go to anjrpc.org. They have links to the actual lawsuit filings. It's on the Carry lawsuit filings page of their website, and I think it's link number 14 to this particular order. And I do know that some of the gun ranges are putting out lists that they've compiled from that. They look accurate to me, but as always, be careful and look at the law yourself. And I get it. This is the problem with carry laws. And the reason we need national reciprocity, you look at just New Jersey's law on where you can and can't carry. I've been a lawyer over 20 years. I can read the decisions. I can read the laws and what was passed by the legislature. I'm not even sure it was posted yet in the statutes, but I can look at all that and I can read all that and I can read these 60-page decisions, and I can make a list for myself. But as I'm traveling around town, everywhere I stop, I'm thinking, oh shit, does this fall into one of those exceptions? Or is this a building that's leased by the government? Is there an IRS office on the second floor? The government owns the building and leases out to, I mean, it's crazy. There are going to be situations where you can't possibly, even if you wanted to, you couldn't possibly comply with every restriction that is still out there. But don't fault any of these Second Amendment groups for that, because there are a legal strategy at play. You're going for a TRO. It's done on very short notice. It's a very short period of time with very limited amount of briefing that's allowed. You can't go after everything. So the issue with the amount of money that you have to pay for the permits, I know the judge actually referenced that, the fees and that being a violation of rights. So it's clearly an issue that's going to be dealt with down the road, but it wasn't made part of the TRO request for TRO because that's pure strategy. You can't throw too much at the judge. You want to get a decision on your best arguments and then take the win on your best arguments and then expand that and argue it should apply to the rest of the prohibitions piecemeal. That's the best legal strategy. I'm glad they're going that way, and it's just going to be a matter of time.